Online at 560theanswer.com. Now, from the Signature Bank Studios. Be a part of AM 560's Republican debate on Thursday, February 26th at Benedictine University in Lisle. Get your free tickets today at 560theanswer.com/debate.
Top of the morning, Dan Prof here, returning to the discussion we started last hour on the Supreme Court decision in learning resources, the tariff case. The president was none too happy, but as I said, none too sad either, because they anticipated this possible outcome, and they are ready with statutory authority that we went over from two particular pieces of legislation from 1962 and 1974 that gives the president, in coordination with the Commerce Department in one section, in coordination with the U.S. Trade Representative's Office in another section, the ability to essentially rework the terms that the president imposed unilaterally, in negotiation with other countries. Scott Bessent, making the call on CNN, made the rounds on the Sunday talkies, making the call across the globe to, for those who have entered into frameworks for agreements on trade policy, you would best continue to abide what has been negotiated, because we're going to get there through the back door, or maybe through the front door. There's probably a better description. We're going to get there through the front door this time, even though we've been there through the back door.
Again, we can move to 232 and 301 tariffs, so I think that everyone is going to honor their deal. And there is the draconian alternative that Supreme Court reaffirmed that the president has. He has a right to a complete embargo. Right. Like, he can just cut countries off. He can cut whole product lines off. We can't receive any money. So, I would call on all countries to honor their agreements and move forward.
Right. So these sections deal with national security, deal with unfair trade practices, Section 122 of the 1974 Trade Act, again, which hasn't been used before for tariffs, but does allow the president to impose tariffs of up to 15%, which he did, for as long as 150 days to address problems allegedly caused by persistent trade deficits. Whether you believe in such things or not, there's federal statutory law that provides for it. So the president is not without power here. And as to these refunds, that there was some question about, so does this mean that the tariffs collected have to be refunded? Well, that's a pending matter.
Question. Will you refund the roughly $134 billion in revenue taken by these emergency tariffs?
Well, Dana, that's not the big question. Let's just level set here. What the Supreme Court did was a very narrow reading of the president's authority under the IEEPA tariffs. We have other tariff authorities which have been functioning, Section 232 tariffs, Section 301 tariffs. And Dana, when you say it's a big question, that's bad framing, because the Supreme Court didn't even address that. The Supreme Court remanded it down to a lower court, and we will follow what they say, but that could be weeks or months when we hear them. So the Supreme Court did not address refunds.
Sure, they didn't address refunds. That is clearly going to be up to you, which is why
No, Dana, it is not up to me. It is
not you.
It is not up to the administration. It is up to the lower court. Let's just be clear on that.
Well, there you go. Boy, it's an odd approach for a dictatorial regime to take. It's up to the courts. Anyway, John Kennedy, senator from Louisiana, suggested that Democrats better be careful what they wish for here, even though Kennedy has not always agreed with Trump and some of his decisions with respect to tariffs.
How can I put this? He believes in being a bear. And he thinks if you're going to be a bear, be a grizzly. And I don't expect Western civilization to end here, and I don't expect the president, whether you agree with him or not, to back up on tariffs. The most interesting question is, what do we do with all this money? We've got between $150 and $400 billion tariffs collected. That money's not in other countries, it's here. My Democratic colleagues are saying, oh, give it back, give it back. Well, my Democratic peeps better be careful what they ask for. Because if he gives back $300 billion worth of tariff money to the business community in America, this economy's going to roar, man. And the midterms are only a few months off.
Well, that's why they don't want it given back to the business community. They want it in the form of checks to everybody, as Pritzker proposed, $17 checks. Just sort of the free money being drop shipped from the federal government. It worked so well during COVID. So yeah, and by the way, the fact that we don't even know how much money we've collected, or it's in a range between 130 and $400 billion. Hey, good grief, government accounting. Kennedy went on to talk a little bit more, though, about tariff authority.
Tariff authority presides with Congress. Now, Congress, on occasion, has shared that tariff authority with the executive branch. The Supreme Court today said we didn't share as much tariff authority with the president as he said we shared with him in the IEPA statute. So he can amend that statute.
Right.
But my point is, in the meantime, he didn't wait around for a Supreme Court opinion.
Right.
He used the leverage from IEPA to negotiate trade agreements. And I don't agree with everything he's done on trade, but if I'm sitting there in the president's shoes, I'm going to take my win.
Right.
And that's why I say my views are, I'm going to take my win.
Right.
And of course, John Kennedy is an officer of the court. He is an attorney. So interesting. I think that's right. And what he described there is essentially the reasoning at least in the Gorsuch concurrence. For more on this, please be joined by Professor Richard Epstein, James Parker Hall, Distinguished Service Professor, Emeritus of Law, Senior Lecturer at the University of Chicago. Professor Epstein, thank you as always for being with us.
Oh, it's always a pleasure to be with you, particularly in these loony times.
Yes. So we've got three different cohorts of justices here on this case. Where do you fall in terms of the reasoning, the competing reasonings offered, and why?
Well, in general, I'm a hardliner when it comes to this. IEPA doesn't come within a country mile of authorizing what the president said. If you start looking at what the Kavanaugh opinion said in its dissent, what it does is it quotes the word regulation and importation and then leaves out everything in between. And that's just not the way you do statutory interpretation when there's so many other issues that are at stake. There's one of the ironies there. The president, therefore, would have equal authority over importations and exportations. They're both in the statute. But if you look at the Constitution, the president has no power, the Congress has no power to put tariffs on exports. And so the statute, therefore, would fall. So you have to give it the more sensible reason that regulation includes all the other things that they put on that very long list: to investigate, block the independency of an investigation, direct, compel, and nullify, void, prevent, prohibit importation or exportation. If you have all those things on a list, you can't sneak in tariffs as though it doesn't exist. So that's the first problem. The second problem is that there is no authority that the president has, I think, with respect to the other statutes, which he's trying to cite in this particular case. They simply do not go as far as he would like them to go in dealing with this. So you take Section 122 of the Trade Act of 1974. It says the president has the power to deal with large and serious United States balance of payment deficits, right? Okay, well, what's a large and serious deficit? The president's definition of this is exactly the same as his definition of an emergency. We've always had deficits. They've always been large, and they've always been serious. His account is that a statute which has never been used even once to deal with this problem is so comprehensive that we could have invoked it any time in the last 35 years. But large and serious means is the balance of payment system such that to disrupt the operation of the economy. And he can't make a case out for that. And so what then goes is the issue that was not addressed in the opinion, any three of them. Who gets the power to determine whether or not there's an emergency that triggers the operation of these statutes? Because remember, that's the precondition. The president's view is he can declare any emergency he wants because there's no external authority. That is just plain wrong. There has to be an independent verification that there's some emergency out there, and none has been offered in this case. And once the emergency is independently established, not by the president, but by a court or some independent board, then he has much greater latitude with respect to the remedies. But he has no latitude in order to declare things and invoke. And when you start looking at this, to deal with a large and serious balance of payment deficit, that's not what Trump is doing. The man's become a child, and he's expressing his pique at everybody in the world by imposing these tariffs. It has no relationship to anything that's going on with respect to the global economy. He first puts it at 10%, then he raises it to 15%, and this is just all in. If you look at the other statute, IEPA, it says you can't use these things for any other purpose. That's got to be implied in every statute. You cannot use them in order to bully whip the United States Supreme Court in your own peculiar way. So Besant is just plain wrong. The biggest mistake, I just put this, that they made the first time round, which leads to the screw up on refund, is after it turned out that the president lost down below, what happened was they applied for a preliminary injunction to stop it, so you would prevent these things from accumulating. The standard test for that under a case called Winter worry about the public interest and, most importantly, about the likelihood of success on appeal, which was extremely high because the case was sound. The intermediate court denied that. So what happens, the tariffs keep on coming when by any standard theory they should not have been allowed to continue at all. That's going to come up at this point. And now one of the things that happens is, if I'm correct, that the statute does not authorize this because there's no independent finding and the definition he's using is much too broad, there should be a preliminary injunction that stops him. And there's more reason to give it because everybody knows he didn't pick this first because there are real constraints on it. He just used it as a backup. He's not made any findings of any of the difficulties that are associated with any of these systems.
Well, but
so
go ahead. I'm sorry. Finish.
But where is the balance of payment deficit that causes serious international location? The only thing that causes this serious international dislocation are his erratic tariff policies. That's not a reason for invoking second statute when he's basically been illegal with respect to his use of the first.
But now address the Thomas Alito Kavanaugh dissent, where Thomas argues that the non-delegation doctrine, which holds that Congress can give away some powers to other branches, but not essential legislative functions, is not applicable here because the essential legislative function, this is not an essential legislative function. The dissent, the power to impose duties on imports can be delegated. At the founding, that power was regarded as one of the many powers over foreign commerce that could be delegated to the president. Power over foreign commerce was not within the core legislative power, and engaging in foreign commerce was regarded as a privilege rather than a right. Thomas goes on to say the non-delegation. One more. Okay. Thomas goes on to say the non-delegation doctrine only applies to congressional powers that implicate life, liberty, and property. And his implication there is that, well, this doesn't. The president's use of tariffs doesn't implicate life, liberty, and property. What do you say to that?
Look, this is just completely wrong. I mean, the first thing, we do have an explicit prohibition in the Constitution about imposing export tariffs. And that clearly is something which cannot be gotten around by delegation. Secondly, of course, these powers can be delegated. The statute requires it. But you have to do the delegation within the limits of the particular statute, and Thomas does not address that. By taking, as Justice Kavanaugh did, the two words, regulation, importation, and dropping out the rest of the sentence, it's a complete distortion of what the statute says. His dissent was absolutely one of the weakest things that I've ever read. I mean, this is a situation when you're looking at delegation, and you know that these are extremely sensitive issues, you don't read these things in a crazy fashion. So there is a dispute between two halves of the majority, as you know. Justice Roberts is very partial to the major question doctrine, and this is surely one of those. Justice Kagan doesn't like it and doesn't think it's needed. I, in fact, agree with her. I don't think you need that in this particular case. You have to go with all those other words about the kind of massive dislocations that trigger the application, and there's none evidence whatsoever is introduced on that. What happens is the whole question of what is meant by an emergency, which is raised in the title of the statute, is never considered by the court. Now, when you get to this next case, where they have to talk about serious dislocations and the like, they're going to have to raise that because it's in the core of the statute. And I don't think that they can make that. And so I regard this as just totally irresponsible behavior on the part of the president. And I listened to Mr. Bessent, I'm thinking of an excuse factory. He doesn't want to come to grip with the serious stuff about him. He just assumes that this statute arises. And in fact, if you read most of the commentary, even in the Wall Street Journal, they seem to say the same thing. They haven't read the statute closely. You have to quote the language from the thing and deal with it. And I would hope that somebody would bring an immediate action to stop this and move for a preliminary injunction, both of which should be granted. He should not be allowed to do this as he did it the first time with massive dislocation unless there's been some imprimatur by a court, because otherwise, in fact, the executive is king, the Congress doesn't matter, the court doesn't matter. The only person who matters is Donald J. Trump.
Well, I mean, but it's not just Trump, because we have three justices weighing in on this. And one of the things that Gorsuch said in his...
a terrible opinion.
Well, I'm not. I mean, that's okay. I get your argument, but I mean, he's not alone on this. Is my point. I mean, three justices, particularly of that stature, those gentlemen of that stature. No, it's not inconsequential. It has to be addressed. But Gorsuch in his concurrence made the point that these justices that are offering sort of a pass on major questions. The use of the major questions doctrine, the way they're addressing it in this case, is exactly the opposite of the way they addressed it in the Biden student loan case. He made that point as well. He sort of insinuated it. Is Gorsuch right on that score?
Yeah. I mean, look, the Biden situation was another illustration of unilateral presidential power in the sheer tape of clear statutes that went in the opposite direction. And what happens is there's too much in common between Biden and Trump. Both of them believe in unilateralism in a very strong degree. And essentially, my view, when you say that the president has executive power, you have to read the rest of the sentence. And that says to see that the laws are faithfully executed. And when you basically misread the statute, you're not doing that. And if you don't do that, then you're not entitled to any deference, which you're normally supposed to be able to get. What's happened is the general rule in statutory interpretation is you assume that the executive branch is acting in good faith. But if you have strong reasons to believe, and the peak really shows that he's not acting in good faith, then all claim for deference starts to disappear, and you're subjected to strict scrutiny. And he can't meet that. The Bessent speech was just awful. In terms of the way in which it assumes that unilateralism is there. Trump did not use the other statutes first because he knew they were weaker. Now that those statutes are struck down, he said, they're just as good as the statute that we had. But he has not satisfied the precondition. So I'm going to ask you again, tell me where the balance of payments situation in the world is in massive disarray. The way he defines that term, this statute could have been invoked at any time since the date of its passage.
Well, yeah, but I mean, but I haven't gone through the intent of the legislation, the Section 122, that Section 122 inspired, or was inspired by the point is that, I mean, there's not like it's a tiered monetary threshold. So if you have a trade deficit and the president says that trade deficit is, presents as some sort of imminent concern for the federal government, then it seems like that statute provides him pretty wide authority, at least for 150 days. At least for 150 days.
No, it doesn't. In my view, I think it's exactly the opposite. You look at the kinds of things that trigger all this stuff. There's a tsunami that starts to take somewhere, and the capital markets on a given issue start to shut down. That's what counts as the serious disruption, and that's where the president.
But that's not in the statute. That's not in the statute.
But when you start talking about a question of what you mean by large and serious, what you're saying is that everything is large and serious.
No,
so
I'm saying I'm just going by the language of the statute and the wide berth it gives the president. I'm not arguing a position of whether the statute was properly crafted.
No, I'm not. I'm just saying take the statute as what do you mean by when they start using the words having to be extremely prolonged and serious. This is a very, very clear statute. And the question you have to ask, as you did with the trade statute, Trump was clearly wrong when he said balance of payments issues deficits are essentially serious disruptive events. They're not. It turns out the balance of payments is utterly irrelevant on the deficit question to the prosperity of the United States. So what happens is we have relatively open free trade policies, and we wipe the floor with the but the Germans and everybody else in Europe have more restrictive policies. What's happened is free trade has been the engine of prosperity, and this man thinks that reciprocal trade is needed, which is a level of ignorance with respect to the economics. He's creating a system calling an emergency, the very situation that makes this country great. He's got it 180% backwards.
Well, I'm oriented towards free trade too. So I agree with you generally speaking on the economics, but what we're arguing is the law and what kind of power the executive has versus Congress, and he has some statutory power.
He does, no, but not to this case. I mean, you look at all the cases, the only time where the tariff issue became relevant was in the Iranian crisis, a very different kind of problem with massive war and withholding of funds. And it turned out they set up this commission. And so there's some maybe residual power. But in fact, if you start looking at the statute, there was a nice piece this morning by Jonathan Adler on Civitas, where I also write. And he says you can look for that whole statute, and you cannot find the word tariff in any operative provision of IEPA. Now, you can find tariffs in the Tariff Act, but there's still a precondition for using it, which has to be this major and serious problem. You have to show that. And there isn't. The problem of world stability and balance of payments is threatened by only one thing at this point: Trump's tariffs. Nothing else has anything to do with it. He's completely erratic about it. But I think it can be said you won't bring down a nation with tariffs because 90% of our economy tends to be internally focused. But what will happen is there'll be lots of disruptions along the way. And so he's basically saying, since I was such an incompetent in the way in which I dealt with the tariffs, I now have power under the Tariff Act in order to change the way in which these things are going on. That's what his argument boils down to. I make a big enough mess of something, and then I'm allowed to make a bigger mess of it under the second statute. The man is not responsible, and his motivation has nothing to do with the economy. He's just mad at the Supreme Court.
Professor Richard, you get the last word. Professor Richard Epstein, James Parker Hall, Distinguished Service Professor, Emeritus of Law and Senior Lecturer, University of Chicago. Professor Epstein, thank you as always. Do appreciate it.
Okay, we do like our sparring matches, don't we?
I do too. It's wonderful. Thank you for joining us. And he joins us on Chicago's Morning Answer. All right, coming up at 8:08, we're going to continue this conversation, at least in part, with Richard Reinsch, Editor-in-Chief of Civitas Outlook, which is just mentioned by Professor Epstein. And then at the bottom of the hour, Dominic Green from the Washington Examiner, a little bit on the Epstein files. It's now 8 o'clock on AM 560 WIND Chicago.
A lot of the Northeast is shut down by a blizzard. I'm Dave Anthony, Fox News. And as the snow comes down hard and sideways in the wind, a lot of cities are dealing with this.
We got about 16 inches of snow about 3.5 weeks ago. Some of that melted, but a lot of it was just piled up.